A unanimous Supreme Court decision came down this morning that legal experts are calling the most important civil rights ruling in 30 years. And here's what nobody's talking about. This wasn't just about gun rights. This 9-0 decision just rewrote the rules for police searches, vehicle stops, and how law enforcement can interact with armed citizens. If you own a gun, carry concealed, or care about your Fourth Amendment rights against unreasonable searches, what I'm about to reveal changes everything. Hit that subscribe button right now, because this unanimous ruling affects every gun owner and every American who's ever been pulled over by police. The fact that all 9 justices agreed, liberal and conservative, tells you how badly law enforcement was violating constitutional rights. Here's what just happened. On April 23, 2026, the Supreme Court issued its decision in Williams v. Michigan State Police, a case involving a concealed carrier who was subjected to a vehicle search during a routine traffic stop solely because he disclosed having a firearm. The court ruled 9-0 that the mere presence of a legal firearm does not constitute reasonable suspicion or probable cause for a search. More importantly, the court held that police cannot use lawful gun possession as a basis for extending traffic stops, ordering people out of vehicles, or conducting Terry frisks. Justice Kagan wrote the majority opinion, joined by all 8 other justices. Here's the critical language. The Second Amendment protects the right to bear arms. The Fourth Amendment protects against unreasonable searches. Police cannot nullify one constitutional right to investigate the exercise of another. Lawful possession of a firearm, standing alone, does not create reasonable suspicion of criminal activity. Let me break down exactly what this means, how it protects both your gun rights and privacy rights, what police can and cannot do now, and the critical things you need to know to protect yourself during traffic stops. Number 1. Here's what the Supreme Court actually ruled in this landmark 9-0 decision. The court established 5 clear rules that police must follow when dealing with armed citizens during traffic stops and other encounters. Rule 1. Police cannot search your vehicle simply because you tell them you have a gun. Before this ruling, many departments trained officers that firearm disclosure justified vehicle searches for officer safety. That's now unconstitutional. Rule 2. Police cannot extend a traffic stop to question you about your firearm beyond confirming you're legally allowed to possess it. If you have a valid carry permit or live in a constitutional carry state, police must complete the traffic stop as they would for any other driver. Rule 3. Police cannot order you out of your vehicle solely because you're armed. Pennsylvania v. Mims allows officers to order people out during stops, but this new ruling says the firearm itself cannot be the reason. Rule 4. Police cannot conduct a Terry frisk simply because you disclosed having a gun. Terry frisks require reasonable suspicion that you're armed and dangerous. Legal carry means you're armed, but it doesn't make you dangerous. Rule 5. Police cannot use your refusal to consent to a search as justification for a K-9 unit or extended detention. If the traffic violation is complete and you're legally armed, you must be free to go. These 5 rules fundamentally change police-citizen encounters involving firearms. Before this ruling in many jurisdictions, telling a cop you had a gun meant automatic vehicle search, interrogation, and detention. Now, lawful gun possession is treated like any other legal activity, irrelevant to the stop. If you're finding this helpful, imagine what you'll learn in my next video, where I break down the exact words to say during a traffic stop to invoke these new protections. Subscribe now so you don't miss it. Number 2. The case that led to this ruling. Anthony Williams was a Michigan concealed carrier pulled over for a broken taillight in 2024. Michigan requires duty to inform, so Williams immediately told the officer he had a CPL and a loaded pistol in his center console. The officer ordered Williams out, then searched the entire vehicle for 45 minutes, claiming officer safety concerns. Williams was completely legal, nothing illegal found. But the officer questioned him about where he bought the gun, why he was carrying, where he was going, and prior arrests. Williams sued for Fourth Amendment violations. Lower courts sided with police, saying firearm possession created safety concerns. The Supreme Court reversed unanimously, holding legal gun possession cannot justify warrantless searches. Justice Kagan wrote, "The price of exercising Second Amendment rights cannot be the loss of Fourth Amendment protections." Number 3, here's what this means for you during traffic stops. This ruling creates specific protections you can invoke, but you need to know exactly what to say and do. When pulled over in a duty to inform state officer, I'm informing you as required by law that I have a valid carry permit and I'm legally armed. My hands are on the steering wheel. That's it, you've met your duty. If the officer asks where the gun is, you can say, I decline to answer questions beyond my notification requirement. If they ask to search, you say, I do not consent to searches. When pulled over in a non-duty to inform state, you have no obligation to volunteer that you're armed. If asked, you can say, I decline to answer questions. Am I free to go? If they see the gun, stay calm, keep hands visible, and invoke your Fourth Amendment rights. I do not consent to any searches. If ordered out of the vehicle, I'm complying with your order. I do not consent to searches or seizures. I'm invoking my Fourth Amendment under Williams versus Michigan State Police. This puts officers on notice that you know the law. If they search anyway, do not resist. Say clearly, I do not consent to this search. I'm invoking my Fourth Amendment rights. Document everything. You'll challenge the search later in court. Quick legal note, this is educational information about the Supreme Court decision and your constitutional rights. This is not legal advice. If you're facing criminal charges or civil rights violations, immediately consult with an attorney who specializes in criminal defense and civil rights law. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these critical constitutional rights updates first. Click that subscribe button because next week I'm revealing what to do if police violate these rules and how to file a civil rights lawsuit. Number 4. Here are the critical exceptions where police can still search your vehicle. Understanding these exceptions is crucial because police will look for ways to work around this ruling. Exception 1. Probable cause of a crime unrelated to gun possession. If police smell marijuana, see open alcohol containers, or have other probable cause, they can search. The ruling only prohibits searches based solely on legal gun possession. Exception 2. Plain view doctrine. If police see something illegal in plain view during a lawful stop, they can seize it and search, but they cannot manipulate your belongings to create plain view. Exception 3. Search incident to arrest. If you're arrested for a traffic violation like DUI, police can search your vehicle, but they cannot arrest you just because you have a gun. Exception 4. Consent. If you consent to a search, police can search. Never consent. Always say, I do not consent to searches. Exception 5. Inventory searches. If your vehicle is impounded, police can inventory contents, but they need a legitimate reason to impound beyond gun possession. The key is that police need independent legal justification for searches. Legal gun possession alone is never enough. Number 5. What police are being told and how they're working around this ruling. Training bulletins from several departments show these strategies. Strategy 1. Ask for consent before mentioning the gun. Mind if I look in your car? Always refuse consent. Strategy 2. Claim they smell marijuana. Odor is still probable cause in many states. Strategy 3. Use K-9 units. Williams doesn't prevent K-9 searches, but does prevent extending stops to wait for dogs. Strategy 4. Separate you from the vehicle to question you, trying to get incriminating statements. Strategy 5. Claim furtive movements to create reasonable suspicion. Keep hands on wheel from the start. Number 6. Here's why this 9-0 ruling is so significant beyond just gun rights. The fact that all 9 justices agreed, including justices who typically support law enforcement and gun control, tells you how egregious police behavior had become. Justice Kagan is known for deferring to police in Fourth Amendment cases, but she wrote this opinion striking down police searches. That tells you the practice was so widespread and unconstitutional that even law enforcement-friendly justices couldn't support it. The 9-0 vote sends a message to police departments nationwide. You cannot use lawful gun possession as a fishing expedition for other crimes. The court saw through the officer safety pretext and recognized it for what it was, a way to search vehicles without probable cause. This ruling also protects millions of Americans who aren't gun owners. The Fourth Amendment principles established here apply to any situation where police use illegal activity as justification for searches. Police can't search you for legally carrying a gun. They can't search you for other legal activities either. Number 7. Here's your action plan to protect both your Second and Fourth Amendment rights. Action Step 1. Memorize your state's duty to inform law. Know whether you must disclose or can remain silent about firearms. Never volunteer more information than legally required. Action Step 2. Practice the traffic stop script. I do not consent to searches. I'm invoking my Fourth Amendment rights under Williams versus Michigan State Police. Am I free to go? Say it out loud until it's automatic. Action Step 3. Install a dashboard camera that records audio. Many civil rights violations happen during traffic stops. Video evidence is crucial if you need to sue for constitutional violations. Action step 4, never consent to searches. Even if you have nothing to hide, consent waives your Fourth Amendment rights and allows police to search without limits. Action step 5, if your rights are violated, document everything. Write down badge numbers, names, times, what was said, and what was searched. File a complaint and consult a civil rights attorney. Action step 6, know that you can sue for Fourth Amendment violations. 42 U.S.C. paragraph 1983 allows you to sue police and departments for constitutional violations. If police searched you illegally after this ruling, you may have a case. Action step 7, share this information with every gun owner you know. Most concealed carriers have no idea that disclosing their firearm doesn't give police search authority. Here's the bottom line. The Supreme Court just issued a unanimous 9-0 decision protecting both your Second Amendment right to carry firearms and your Fourth Amendment right against unreasonable searches. Police cannot search your vehicle, extend stops, or frisk you simply because you're legally armed. This is a massive civil rights victory beyond just gun rights. The court recognized police were systematically violating Fourth Amendment rights by using lawful carry as a pretext for searches. But you need to know how to invoke these rights. Saying nothing won't protect you. You must state, I do not consent to searches, and I'm invoking my Fourth Amendment rights. You must refuse consent and document violations. Police will train officers on workarounds, consent requests, probable cause claims, extended stops. You need to be informed and firm about your rights. Subscribe right now, because the next video reveals exactly what happens if police violate Williams and how to file a successful civil rights lawsuit. Share this with every gun owner. They need to know their rights just expanded dramatically. Remember, this is educational information about your constitutional rights. Always consult an attorney for specific legal situations. Your Second and Fourth Amendment rights just got stronger. Use them. Thanks for watching. I'll see you in the next one, where we break down the first lawsuits filed under Williams and what they're winning.